Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. It is Tuesday, April 25th. It has been a bad day. Nope, strike that. It has been a terrible day. Strike that. It has been a horrific day if you actually enjoy what are supposed to be inalienable rights. Because earlier today, Governor Inslee signed into legislation House Bill 1240, Washington's assault weapon ban, with an immediate enactment, which means as of the recording of this video, that is good law. He also signed into legislation Senate Bill 5078, a piece of legislation clearly designed to drive the entire FFL industry out of business in this state, and House Bill 1143, a pre-purchasing educational requirement that does not take effect until January 1st of 2025. Bottom line is, it's been nothing but bad news today, and bottom line is it's been nothing but bad news for week after week after week, and I have not enjoyed spreading all of that bad news here on the channel. However, just maybe there is a ray of hope. Maybe we've already begun to see what the next chapter is going to look like. Because as I told you, we may have lost the battle, but we are still going to win this war. So today, let's spend a few very important minutes. Let's visit with a few guests and talk about when a governor strips its citizens of their rights, lawsuits will soon follow. Okay, so the issue we're talking about now today is with House Bill 1240 being signed into legislation and the emergency enactment clause being there, which means this is now good law. Let's see how the litigation might be shaping up already. There is not one but two lawsuits that we're going to be talking about. The first lawsuit is the one that we kind of hinted at for the last couple of weeks. That is the suit of Guardian Arms LLC v. Inslee. That was filed in the Grant County Superior Court just moments ago by none other than Pete Serrano of the Silent Majority Foundation. We're going to be joined by Pete in just a moment and talk about that lawsuit. We're also going to talk about a second lawsuit that was filed in the United States District Court for the Western District of Washington as soon as we're done talking to Pete. But in the meantime, let's get out to Grant County. Let's talk to Pete Serrano about the lawsuit that was just filed out there. All right. Hey, listen, I am joined by the one, the only, except no substitute, Pete Serrano from the Silent Majority Foundation. Pete, you appear to be outside the Grant County Courthouse right now. What's going on in Grant County today?
Oh, we just, filed a couple of pieces of paper here. We're seeking the temporary restraining order as promised on behalf of Guardian Arms and a couple of fine citizens here in Grant County. These guys are some of our plaintiffs. Thought I'd introduce them. Go ahead.
Please do.
I'm Nathan Poplowski, the owner of Central Basin Shooting School. I'm Mike McKee. I'm Edgar Salazar, the founder of Guardian Arms. I'm Bruce Davis, the CEO of Guardian Arms.
Excellent. Gentlemen, thank you so much. And listen, for all of my viewers out there, these are the guys that are willing to stick their necks out, be the plaintiffs on this thing, be the tip of the spear as we try to overturn some of this insanity. Pete, the name of the suit is?
Guardian at Arms and others versus Jay Inslee and others, because we're suing Jay and Not So Silent Bob and then the local sheriff here.
All right. Guardian Arms v. Inslee. Now, this was filed in Grant County Superior Court. Tell us a little bit about game plan now. You filed for a temporary injunction. Did you file a motion for an emergency temporary injunction?
Yeah, we did seek an emergency temporary restraining order, and we contacted the AG's, the Attorney General's office. So they're aware that this thing is percolating, that it'll be sent to them by the end of the day. And we were told that the judges will look at their docket and we'll get assigned someone hopefully by end of day. And we could have it heard or decided at least on the temporary restraining order, fingers crossed by the end of the week or early next week.
So what you're saying to the viewers, and again, this is the old, Dumb and Dumber, so you're saying there's a chance here, but we could have a hearing as early as the tail end of this week or early next week in which we're going to be arguing about whether or not this law should remain in effect or be enjoined pending the outcome of all the litigation, right?
Yeah, I mean, that's the hope. And what will happen is if they grant this, they could technically grant this ex parte, meaning without a hearing. And if that's granted ex parte, then the state has 48 hours to oppose the motion. At that point, then we'd have a full-blown hearing for the temporary restraining order, which is good for 14 days. And then after the temporary restraining order, what we'll see is a motion for preliminary injunction. And that would be good through the pendency of litigation. Obviously, I think if we get a TRO, a temporary restraining order, granted, the governor's office, the attorney general will be moving very hastily to get this thing to Olympia in front of the Supreme Court on some emergency basis. That's what we've seen when the judges are actually, doing what judges do and think independently.
But we ran into a similar situation down in Oregon. I know some litigation that you're involved with out of Harney County there, where the state of Oregon not once but twice went stampeding to the Oregon State Supreme Court, a court that's politically quite similar to the Washington State Supreme Court. They never touched that thing with a 10-foot pole. Are you as hopeful about that with our state Supreme Court if we end up in that hypothetical situation there?
Yeah, to your point, it's a very similarly politically situated court. I've given it a lot of thought, and I'm hopeful that they'll just follow suit. And what we saw in Oregon, as you mentioned, the state court in Harney County issued the injunction. The Supreme Court twice denied the desire to hear it on a temporary or emergency basis, and they're letting the federal courts play out the actual full injunctive relief. So I think we'll see something similar.
Okay.
I really do.
Now, the injunction, just so we're clear, if you were to prevail on an injunction in Grant County, that would be a statewide injunction. That would stop this law from being enforced throughout the entire state, correct?
That's what we asked for, was the full swath of injunctive relief. So theoretically, it should be all 39 counties.
Okay, now, a couple last questions here. So we know there's a lot of different ways to skin the cat. We can come over to this through federal constitutional grounds, state constitutional grounds. Strategically, where did the Silent Majority Foundation decide to go with this particular suit in Grant County?
We pled this purely on state grounds. We obviously cited Bruin because the analysis that the Supreme Court's given is what will bind every court in the nation. So we're pleading purely on state grounds with the anticipation that it doesn't get moved.
Okay. And as we are also privy to, and we'll be talking about it here in a moment, there is already a second lawsuit that's been filed into the Western District of Washington, which is now filed in federal court. So as of the recording of this video, we have at least one lawsuit filed in state superior court and one lawsuit filed in federal district court, correct?
Absolutely.
Okay, Pete, last question, but the most important question. A lot of my viewers are going to want to get some skin in this game, want to help the Silent Majority Foundation out. How can people give back to the Silent Majority Foundation and help out with this litigation?
Website is smfjb.org, silentmajorityfjb.org, and you can donate through those links that are available there, either to our Second Amendment Foundation or to the general operating funds. But again, I want to give a shout out to the five guys behind me. These guys are the ones really sticking their neck out. They're either individuals who just care about the Constitution, care about your rights, or people who stand to lose business because of the bad policies of the governors. So definitely wave and say goodbye. Thank you, guys. We really appreciate you. And it's my pleasure to stand for them and the state of Washington. So
listen, to all your plaintiffs, gentlemen, thank you so much for having the courage to stick your neck out. We need exactly people like you. We need attorneys like Pete Serrano. So here's to many good days ahead. I know today was a bad day, but I can't wait for a video somewhere down the road where we're doing a lot of verbal high fives. Okay. Thank you, gentlemen, for your time. Thank you, Pete.
Thanks, Bill. Take care, bud.
Okay, thanks again to Pete and all of the brave plaintiffs who not only are willing to throw their hat into the ring for this fight, but were willing to make their appearances and identity known on video. We applaud all of you. Now, I also want to give you another piece of good news, because in addition to Guardian Arms versus Inslee, the suit that was filed in Grant County Superior Court, we also have a second lawsuit. And that lawsuit is the matter of Hartford v. Ferguson. Now, this is a lawsuit that is filed in the United States District Court for the Western District of Washington. I want to list all the plaintiffs. Some of them are going to sound very familiar. There is Lawrence Hartford. There is the Second Amendment Foundation and the Firearms Policy Coalition. So a lot of big hitters behind this lawsuit. Now, this lawsuit was filed, as I mentioned, in the United States District Court for the Western District of Washington. It, too, is seeking injunctive relief. It is asking for an emergency injunction. This lawsuit, unlike the one that we just talked about with Pete Serrano there in Grant County, which is pursuing the challenge under state constitutional grounds, Article 1, Section 24 grounds, This particular suit, Hartford v. Ferguson, is again approaching or attacking this legislation under federal constitutional grounds, specifically that this violates 42 United States Code Section 1983. Now, for those of you who went to law school, we all talked about 1983 claims. For those of you who didn't, let me just break it down for you real quickly. A Section 1983 claim is where a plaintiff says, hey, you know what? I am being deprived a constitutional right under the color of state law. That means that the state is acting in such a way, such as, enforcing a new gun law, such that it is now infringing upon my individual liberties and constitutional rights. We call them Section 1983 claims because it's filed under Section 1983 of Title 42 of the United States Code. Now, this is the most important thing. Obviously, the constitutional grounds, which are being deprived by the enactment of this legislation, is an individual's Second Amendment right. So this lawsuit is pursuing those challenges under federal constitutional standards. Now, a lot of you think, well, there must be a huge difference. No, there really is not, okay? Arguably, I do think that Article 1, Section 24 of the Washington State Constitution may provide heightened protection over its federal counterpart, the Second Amendment. But, however, this is what we need to be aware of. The commands of the Second Amendment apply to every citizen in every state. The case law that interprets the Second Amendment applies to every citizen in every state, which means when we go back and we take a look at the common use test in cases such as District of Columbia v. Heller, and we take a look at how the single part analysis has been clearly hashed out in New York Pistol and Rifle Association v. Bruin, yes, that case law, that legal structure still applies to all the arguments we are making in Washington state courts, whether we are doing that in the United States District Court or in a county superior court. Now, I should point out that we tried to get a hold of Joel Ard to see if he could hop on and do a quick interview with us. We were not able to reach him. Joel, the invite is always there for you. We have, as you know, already talked to him before. He is the lead counsel in the matter of Sullivan v. Ferguson, so obviously this litigation, just like Pete Serrano, who's the lead counsel in Brumback v. Ferguson, so both of these lawsuits are in really, really good hands at the current time. The other thing I want you to be aware of, and this is the most important thing to watch for, is the injunctions, okay? Because an injunction, if an injunction is imposed by a court, what it basically does is it puts this law on pause, which means there is no aspect of this law that can be enforced by law enforcement, which also means the FFLs can turn around and start selling inventory as if this is still the United States of America. This is why I want you to be very conscientious about the injunction and the arguments for injunctions, because if a plaintiff wants a temporary injunction, wants the judge to hit the pause button while this case is resolved, they got to essentially prove two things. The first thing is that there's going to be irreparable harm. If you allow this law to take effect, I'm going to be harmed in such a way that I will never be able to recover. You will never be able to make me whole. So for some of these plaintiffs here, these FFLs, where they're operating on paper-thin profit margins already, you just strip them of 40% of their inventory. They're going to go under, they're going to go bankrupt, they're going to go out of business, and that is irreparable harm. The second part that you have to prove, and this is really important, is that you are likely to prevail on the merits, which means if we see any court in this state grant an injunction on this law, that is the court telegraphing that, hey, yeah, the plaintiff is going to be seriously messed up by this law, but it's also telling us that, hey, I've had an opportunity to review the arguments, and I think the plaintiff's right. Listen, we're going to put some links down below in the description box. Guardian Arms, one of the plaintiffs there in the matter in Grant County, has their own YouTube channel. They're trying to get it off the ground. I think they're doing some pretty good work, so check them out. If you want to donate to the Silent Majority Foundation, the links like that will be down below in the description box. And let's remember, we still got our first ever Freedom Friday this Friday, April 28th at Security Gun Club. Show up, bring your checkbooks. All proceeds will be going to the Silent Majority Foundation. If you guys got any questions about any of this stuff, you should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. All of that information is right there in the description box. In the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.